some introductory call the meeting to order comments, Ms. Chair.
And just as a reminder, since it's our first meeting of 2022, we have to vote on a chair and a vice chair for the year.
Okay, let's go ahead and try to get that out of the way here. Do we have any motions or nominations for chair?
So let me say, I don't know if that was on the agenda, and I think we typically would take nominations from the board in advance. If the board's not ready to proceed on that, we can push that to the next meeting.
It was on the agenda, but it's up to the board if you'd like to do that. I will say that while it's a pleasure serving as chair, I am certainly willing to pass the baton if anyone is interested in running these meetings. It doesn't make any difference to me whatsoever. So it's up to the board.
I was going to nominate Emily to just keep doing her fantastic job.
I agree.
Second.
If she'll have us.
All right. Well, all in favor, please signify by saying yes.
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 Any opposed? The motion carries. Thank you very much. I appreciate the confidence. And then we'll do nominees for the position of vice chair. And I'd like to nominate Mr. Moran again.
That's very.
A second.
All in favor, please signify by saying yes.
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 Any opposed? That motion carries as well.
Thank you.
So, sure, no problem. And I guess at this point, we can now turn it over to Mr. Sturkey for a briefing on the changes to the code and the rules for the Board of Zoning Appeals.
Sure. Emily, did you want to start with the background about the actual, the text amendments?
I think that would be helpful.
Yeah, so I can give a brief overview of what the changes are. The two main changes are certainly that the ZBA is going to be the body reviewing all urban design overlay applications and in the process for demolition review. So I will share. Okay. So on the screen, you can see the previous demolition review regulations, and the "and" is circled in here because what these regulations for demolition require is that the demolition be ordered by the Director of Buildings and Inspections and meet one of 5 additional conditions. So the revision really started out to correct that, because under this existing language, you could not demolish a building in a UDO unless it was ordered by the Director of Buildings and Inspections for public health and safety reasons. And this is problematic in cases like a fast food restaurant in an urban design overlay, which may be vacant and may not contribute to the character or the walkability of the district, but you really can't demolish it unless it's an issue of public health and safety. So with all text amendments to the code, the city planners conduct staff conferences and public engagement. And through that process for this amendment, we really heard that more robust regulations surrounding demolition in these overlays were requested. And neighborhoods were not supportive of a change that made it easier to demolish buildings by simply sort of changing that "and" to an "or." And so that's how we wound up with the regulations that we have today. And what that resulted in is 2 different treatments of process when a demolition is proposed. So we have introduced—
Emily, yeah. I'm sorry to jump in here, but I don't know how familiar the board members are with just urban design overlay districts in general and how the process currently works. And I apologize if this is part of your presentation, but if not, could you take maybe 2 minutes and just do a quick overview of that?
Yeah.
That baseline.
Yeah, certainly. So our urban design overlays, they generally correspond to our neighborhood business districts, and they're really intended to promote economic development and preserve the character of those business districts. So currently, each business district can adopt, there's sort of a menu or a table of different standards that apply. And each neighborhood chooses which ones they want to apply to their business district. And in any design review, any application, any building permit that comes in for work in those overlays, the first step is the zoning staff reviews to see if they comply with the applicable regulations. So if it's an alteration, if it's an addition, if it's minor work, a new sign, staff is looking at the building permit and saying, does it meet the base zoning as well as these urban design regulations? And if we determine yes, and it's that minor classification of work, then we approve it at a staff level. If it doesn't meet the urban design regulations, that's when in the previous process, it would go to a hearing with the zoning hearing examiner, which will now be coming to the zoning board of appeals. And then any demolition and any new construction in their urban design overlay requires a hearing. No matter what, just to determine that it meets the urban design overlay standards, which are generally looking, each urban design overlay has its unique plan for the neighborhood. And these range, some are very old, some have been recently updated. So they really range in the level of detail that they include, but they generally, they map what the neighborhood's needs are, what the future plan is, what's desired for redevelopment, what the goals of the urban design overlay are. So with all new work, particularly the larger scale new construction projects, but we're looking at that urban design plan and the additional regulations in the code for that specific overlay. A lot of the neighborhoods are currently in the process of updating their urban design plans. Specifically in response to these changes to make sure that there's a fresh review of their goals for the urban design overlay and what they think currently contributes to the character of their business district and what doesn't. So those plans are really the guiding principle that we're looking at, that we will be citing in our reports when we bring them to you.
Emily, has this been in effect for a while? I'm not that familiar.
It has been. I have to look back at the, but for decades. I mean, some of these reports are decades old that have actually adopted the urban design overlay.
I was aware that if the community or if somebody had proposed changes to zoning, that had to be considered. Is this along those lines, or is this something different?
I mean, typically when we're evaluating a project, if there's a zone change under consideration, we'll include that in our recommendations. If that's what you're referring to. Yeah,
and then I'm sorry, who's staff on this? What department?
The zoning team is the reviewer. So it's in the city planning and engagement department, but zoning is doing the review. So we do the initial intake, typically through the building permit process. And that initial evaluation of compliance or not compliance with the urban design standards.
And Bob, I know coming from the Historic Conservation Board, one of the things that's going to be normal to you is you've got a district and you've got guidelines for that district. And the question is, does the new development in that district meet those guidelines? And urban design overlay districts in some ways operate much like a historic district in that we've got a special area with special characteristics and there are special guidelines or rules to be followed. I would say one of the main distinctions between urban design overlay districts and historic districts is where historic districts generally make it much more difficult for the districts to evolve or change. The urban design overlay districts are designed to allow for that, but to do so in a way that doesn't really destroy or harm the existing character. So these are meant to be able to evolve in some way as compared with historic districts, which really are not meant to, at least not to the same degree.
Great. And I don't want to occupy the whole meeting here, but how would this get appealed? Are we going to get to that point, or? I mean,
Yeah, and I don't know, David, are you going to talk through that later, or do you want?
Yeah, but I mean, it starts how Emily has described, where someone comes in with a project and they do an evaluation of whether or not, it complies with the individual district standards. And then if it doesn't, that would trigger the start of it's really, this won't be an appeal process. This will be an initial application and request for zoning relief after a determination of non-compliance. So that's what I was planning to get to in just a minute here.
I was just curious, because if the appeals board is actually making the decision, is the next step, if there's a disagreement, to go to court, or?
That's correct.
Okay.
Yeah. We essentially, ordinarily, these would come to the zoning hearing examiner or the zoning hearing examiner, and the new rules is essentially just, have put the ZBA where the zoning hearing examiner was. And as a result, it's sort of taken the ZBA out of any appellate process for these applications, and any appeals would go directly to the Court of Common Pleas.
And just to give a little background on the reason for that is, when we were going through this process and working through some of these changes, the communities were very loud in saying, we want to have more than just one single person making these decisions. We think that these are decisions that are big enough and weighty enough, they need to go to a board. And at least in the recent past, many of the decisions that were being made by the hearing examiner were already landing in front of this board. So it made sense to both, address the public, the request from the public that it be heard by a group of several persons, and the fact that this board was seeing these cases in most instances anyway, that's why it landed that way.
Is this the specific issue that came up, the demolition issue in the Mount Lookout development case? Barry Rosenberg?
Yes, that's correct.
That's what I was wondering too, is.
And so this is to create a process to approve demolition beyond being ordered for reasons of public health and safety.
I do want to clarify, though, that while that is an example, and probably one of the top examples that gave rise to these changes, there were other examples, including on the other side, where communities wanted demolition to proceed, that caused more of a wholesale revisiting of the rules.
And throughout the process of proposing these amendments to the code, there were many different community councils that were involved that helped sort of craft exactly how these would come out, including Mount Lookout Community Council.
What's our workload typically? How many of these cases have there been?
It's not a significant volume. I'd say on average, probably around 10 a year.
Okay.
It may range from anything, like a sign size variance to large scale new construction review.
Maybe since David was getting married pretty soon, he was trying to reduce his workload. That was funny.
That's funny, Bob. No, I don't think I have that much weight to change the code, but that's funny. It will reduce my load just a little bit.
Okay, so so back to the specific changes around demolition. What the public engagement resulted in is these two different paths forward, or processes for review of demolition. One, if a building contributes to the physical character and economic vitality of the district, and one, if it does not contribute to the physical character and vitality of the district. And we're using the words contributing and non-contributing, But it's important to note this is different than in a historic district. In the urban design overlay, we do have very specific definitions for this application, which are included in the code. And it's really only for the demolition process. It doesn't, whether you're contributing or non-contributing, it doesn't impact what's permitted in terms of alterations or additions to a building. It's just the demolition review. And so the process that's been established is for a non-contributing building, it can be demolished with no plan for redevelopment in place if it's determined to be non-contributing through a public hearing with the Zoning Board of Appeals. And that is by weighing 6 different standards that have been introduced. So the first standard in making this decision is whether the building is identified as a contributing building or non-contributing building by the applicable urban design plan or another applicable community plan approved by City Council. So this is pretty straightforward. As I said before, these urban design plans vary in their level of detail. Some of the existing plans do include contributing and non-contributing, and some don't. And many neighborhoods are undergoing the process to add these to their plans now. So Mount Lookout recently just went to Planning Commission to amend their urban design plan to update contributing and non-contributing status. And we have multiple other neighborhoods who are working through that process. The second criteria is if the building's recommended for demolition by the urban design plan or another community plan. And this, this could be in the way of there's a very specific redevelopment requested for a site in the community's plan. So it's very clear that a building needs to be demolished to meet the intent of the urban design plan. The third is, really looking at the character in relation to the overlay. If the building's architectural style, bulk, shape, massing, scale, form, and setbacks are consistent with the predominant characteristics of the district. Again, is it out of place or is it consistent with the streetscape features? The fourth is if the building's iconic or specially associated with the district. So, it may not be consistent with the scale or character, but there may be something unique and specially significant about the structure. And we see many of these in our business districts. And the fifth is the demolition going to negatively impact the streetscape? And this is, part of the difference between a historic district and an urban design overlay, because we're looking at really more so the urban design and the streetscape character. So, like in a situation like this, the individual buildings may not have a significant design or character, but if you take one of the buildings out in the streetscape, you're really going to feel that gap. And that's what this standard is getting at. And the sixth is, really allowing a factoring in of the condition of the building. So if the building's obsolete, damaged, in a state of disrepair, dilapidated, unsanitary, and factoring in that if that condition was caused by the owner or their predecessors through deliberate action or willful neglect. So those are the 6 standards that we would use to evaluate if a building's non-contributing. If it's determined to meet these standards, then the ZBA could approve the demolition as is without a formal plan for redevelopment being brought forward simultaneously. The contributing process, this is really the additional review that was added to give that comfort level that we're not going to be demolishing buildings that contribute to the character and the streetscape in our business districts without a plan to replace them with something that's equally compatible and consistent with the character. So it does permit demolition of any building in an urban design overlay if it's going to facilitate the construction of a new building that contributes to the character. So there are 3 different standards that are 3 different sort of requirements to meet this demolition approval if it's a contributing building. The first is that you've obtained final approval for the new building or the change of use of the property. So that means that you need to bring forward the new construction at the time of the demolition to get it approved. And we understand that could be a high bar to set for developers or a lot of investment in plans at the outset. So we've also revised the code to allow for a two-phase process. So you can bring forward, a first review of the new construction that is really schematic plans looking at setbacks, height, placement, massing. So you kind of get your box that you're going to build in approved, with the condition that you're going to come back for a second hearing with that design fully detailed out with materials and your full elevations for a final review. And nothing is fully approved until that second review, but it gives that comfort level to move forward with development of plans. And so an applicant can certainly bring fully designed plans together, in one hearing. But if they want that phased approval, we've built that into the process. So you have to have your approval.
Emily, if I could just jump in real quick, wanted to just provide a little background on that as well. And the idea was to try to avoid situations where we are requiring somebody to make a substantial investment up front. So they're essentially pregnant with the project and it becomes a high stakes hearing. They have the option where they could simply put a purchase option on a property, create some initial design drawings without engaging full architect and engineering at that point in time, and get a decision whether the scale and density of this project is something that's going to get approval, is going to have significant community pushback, and be able to make a smarter decision early in the process versus these all or nothing hearings that we tend to see. Now, somebody can still request that, and if they want to make those investments and purchase the property and move forward with a full-blown design review hearing, that is the option of the applicant. But we did want to provide that option to break it up and to hopefully relieve some of the pressure on everyone in the meetings at an early stage, so there can be a more reasoned decision whether it's a go or no go project.
So you have to have your ZBA approval of the replacement structure. You also have to have all building permits necessary to approve that replacement structure prior to issuance of the building permit for the demolition. And this is really getting to that comfort level. The work is going to move forward, that we're not demolishing a building and leaving a gap in our business district, that they have really moved forward to that approved permit stage for the new construction. And the third is that the applicant has certified, either just with an affidavit or with sworn testimony at a hearing, that it is their intent to pursue the construction of the new building or the change of use that they proposed. Really, again, sort of getting that comfort level that this is a real project that's going to move forward and not just going to be a gap in our business district streetscape. So that's the basic summary of the changes to the demolition process, which was really the significant change that we made. It's that two basic treatments that either it's non-contributing as determined by the board and approved by the board to be demolished without a replacement plan, or it's determined to be contributing, in which case you have to have a fully approved redevelopment plan to approve the demolition. Happy to answer any questions.
Were all of the community councils who engaged on this supportive of the final product here?
Yeah, I mean, I think we got a general consensus. I think there were probably still some details that not everyone agreed on every detail of the final code.
Okay. Good.
Yeah, I think general consensus is the right way to put it. I don't think it was 100% across the board, every detail of the changes, but I don't think there was significant pushback as it worked its way through council.
So these would still be similarly as we do on the historic board. The staff report would qualify like a 2-year period where you'd have to get your building permit for this to be in effect, right? Because you can basically get in front of the zoning before you know whether the building's legal by building code.
That's correct.
Okay, any other questions about the changes to the law or to the code there, or anything about that process?
Where does like home base, I mean, community councils are one thing, but they aren't always proficient in development. Where did home base and the CDC stand on this?
You know, Mary?
I don't know, Jessica. I don't know if they engaged in the process or not. But going back to the earlier statement, those who were engaged, and it was a very wide range, and people who were more pro change or new development in their neighborhood, and neighborhoods that were, more reluctant and more concerned about development in their business districts. So I do think that, all of those kinds of perspectives were represented through the process. I also think, if I recall correctly, I think the port was involved. I think maybe the chamber. So there were other outside business groups that participated.
And I think it's important to keep in mind too, that while this is a robust process, it is a more permissive process than the previous code allowed.
Can I ask who was engaged from the community side? In other words, who showed up? I'm not sure. Was anybody from Westwood there? Because
Mr. Eby, I don't recall, but I will say, Westwood does not have an urban design overlay district.
right.
And this is one of those issues that was of greatest concern to the neighborhoods with those districts. And even within that subset, there were really only a few neighborhoods that were very concerned, because of our 15 urban design overlay neighborhoods, I'm going to say only about 6 or 8 of them have any actual development pressure at this point in time.
John, you got your Dora. I don't even know why you're worried about this.
Because I'm the guy who gets the phone call, like, who was the idiot downtown that came up with these rules?
And
Right.
if I recall correctly, this passed planning commission with a full endorsement. So
Yeah. This guy.
I know that the planning department managed the public engagement portion as this ordinance worked its way through the process. And so they may be able to provide you an exact list of exactly which people showed up to these meetings and what communities they were from. So I think, what I was planning to do was just really quickly sort of cover some of the changes in the rules of procedure that you're being asked to adopt today. There wasn't a whole lot. Most of them were basically just trying to update the rules to reflect the new requirements in the code that Emily just discussed. So we had to create a whole new meeting procedure that allowed you all, and it's very similar, as you may have noticed as you look through it. It's towards the end there. It's very similar to the de novo hearings that the ZBA has to have occasionally. And so there are changes throughout the actual rules, but most of them, again, are just to sort of make sure that we're incorporating applicants now, is what we're calling them. And anytime you see the word applicant in these new rules, it's to reflect that this is someone who's coming in front of the ZBA, and this is for a UDOD project. And it's the first time they've been in front of any sort of quasi-judicial board or in any quasi-judicial hearing. And so wanted to make sure that the rules reflected that. Another small change that we made while we had the opportunity to update these rules was that in section 2G and section 4, section 4H8, these are like the ethics and conflicts of interest rules within the rules of procedure. We wanted to update those to make those consistent with state ethics guidelines. Previously, we had sort of baked in our own process for determining conflicts of interest and things like that. And so we worked with the Ethics and Good Government group here in the law department to make sure that these were consistent with the state regulations, because we just thought that would make more sense. So any of those changes, again, and I think the most significant ones were in section 4H 8 through 10. We wanted to make sure that those reflected the state guidelines. As you go into the new procedures, that's section.
Hey, David, I'm gonna just make a couple points on that while we're here. So I wanted the board to understand is these changes around the ethics rules do not in any way change or expand laws that board members are already subject to. So this is really just carrying through what state law already provides. Also, I don't know how many of our board members are familiar with some recent changes that were made at City Hall, but among other recent enactments by the council was the creation of a position within the law department known as the Ethics and Good Government Officer, which is essentially a new staff person within, he's an attorney within the city who's dedicated to providing guidance on the potential for ethical conflicts and the like, and to provide recommendations on how to act on those potential conflicts. So what we've done here is strip out a lot of the old language that really talked about a process that wasn't really the correct process anyway. It's very simple now. You know, we've got state ethics laws. If you think you have a conflict because you, a relative or a business associate has an interest in a matter before the board, you should contact me or David. We'll get you in touch with the Ethics and Good Government Officer as soon as possible is best. And then we'll provide you some advice and direction. And if it gives rise to a conflict of interest, you should recuse and not participate in that meeting. You know, ethics laws themselves are can be fairly complicated and there's a lot of gray, but I think in terms of this process that we've put here, it's just very straightforward. Call a lawyer and get advice before acting on anything that you may have suspicions as a conflict of interest. Good. So thanks. Go ahead, David.
Thanks, Mary. Yeah, so point your direction again to the most, I think, significant changes here. Section 5, I think it's on the last page here, section 5D. These are just the new procedures that we'll need to follow for any of these UDOD cases. Emily touched on it before, but this is really any application inside of a UDOD. So not just for, you know, like a big project like the Mount Lookout thing. This is really anything from a sign, you know, updated signs, awnings, changing windows, really anything that the zoning department determines in these UDODs that doesn't comply with the regulations. So you guys will hear all of those, no matter how big or no matter how small. Again, this will be sort of their first hearing. So there'll be a staff report that's produced as they go through the application process. There'll be a staff report produced by Emily's division, which will be shared with all of you prior to these hearings, that will break down the project and will ultimately make a recommendation for approval or denial, and recommend certain conditions be attached to that approval or denial. So you all have a chance to review that before these hearings. There's also attached to the email that I sent yesterday is a new application, and that will be specifically for these ZBA cases in UDOD districts. It will allow them to indicate whether they want to do that one-part process that Marion discussed or the two-part process. And so you all will be aware of that, and that'll be indicated again in the staff report and in the application materials as they come to you on these cases. When folks do appear in front of you, I mean, the process is a lot like what would be a de novo hearing. you'll have to start by allowing the applicant to explain the entire project, background, reasons why they think it's appropriate, reasons why you should grant the relief. You all will be, I mean, you should be familiar with the variance standards, but these could come in the form of variances, use variances, special exceptions, conditional uses. And so all of those standards will be outlined in these staff reports. And of course, are in the code, but those will be the standards that you'll need to apply depending on what exactly the type of relief is to these cases. And those are what the applicant should be presenting to you in these cases. And then again, if you just go through, I mean, it's pretty self-explanatory. And I think, again, if you've done de novo hearings, it'll be about the same, but cross-examination of the applicant is allowed when there's an attorney involved. Parties of record with standing are allowed to make presentations. If attorneys are involved on either side, there can be cross-examination. There will be a report from government officials, which will be Emily's staff, the zoning staff who produced the report. And so we'll allow them to make any comments. They cannot be cross-examined. And so any attorneys, they can cross-examine folks that have testified at these hearings, but they cannot cross-examine any government officials. There is a portion to allow the public, anyone from the public, to attend these hearings and to provide brief testimony, which is limited to 2 minutes. There's an opportunity for rebuttal. Again, that's at, I think, the chair's discretion is how we have wrote that in there. So after each side has had their opportunity to present, the chair can allow rebuttal and then ultimately closing statements. That's typically how the process will work. That's how it'll work for all of the different types of relief and all the different applications that come through with UDOD. So yeah, any questions on anything about that process?
I have a question. So obviously this is an expansion of this body's from an appellate purpose to we're now hearing de novo cases. Was there discussion about forming a separate body to hear this? Because it really is kind of a big functional change from an appellate. I mean, we're from an appellate. I mean, it's a pretty drastic change.
It is. There were not discussions on creating a new body for this. I think we've shared everything that was discussed in the initial when they were initially deciding whether or not to do this. I think a lot of these community councils. I don't think this was mentioned before, but they talked about some of the costs to get to ZBA. So a lot of these would end up in the ZBA, but the costs were a bit of a problem or a hurdle for some of these community councils to get into the ZBA. There's costs involved with the transcript, and there's costs involved with just the application fees. And so I think part of this was trying to relieve some of that burden for them as well. But yeah, you're right. This is a sort of an entirely new function for this board. And it's not appellate.
So just to be clear or state the obvious for myself, we're still going to have appeals cases where no new evidence would be allowed. And now we're also going to have cases where it is going to be new evidence for us. And there's going to be a clear distinction. I guess that's our Madam Chairwoman, I guess, or whoever sets the agenda. I mean, that'll be.
Yeah, and that's something that may be worthwhile to discuss. I mean, we could orient the agenda in a certain way where these cases are separated or there's a clear distinction as they come through. I think that's sort of up to you guys how you'd like to hear them. If you'd like to do sort of the appellate cases first and then go to these, or vice versa.
So from my perspective, I think hearing the appeals first would lead to less confusion because if someone has an appeal following a de novo hearing, they're going to think that they have the ability to bring in new evidence and do the same thing that the hearing before happened. And obviously the appeals are much more restricted in that respect. The one thing I know, and I know we've gone back and forth of this over the years, that I'm not trying to push for it. I know we don't have time limits on these, but I think for planning purposes, it would be helpful if when we are preparing these cases and putting them on the agenda, that if we ask the parties, how much time do they think they're going to need, just so we can have an agenda that is manageable if there's multiple items on the agenda, or in that the board members can, plan their day appropriately and have, allotted an appropriate amount of time for these. I know we've run into the situations. It's rare though, where we're still at it at 1 o'clock in the afternoon, and a new case. It's I personally remember having to leave, and these poor people stayed on the line for 3 hours, and then I had to excuse myself just because I had another obligation. I had to be in court. So it would be helpful just to have an estimate of how much time the parties they think they're going to need. We don't have to hold them to it, but it might just be helpful for planning purposes.
Emily, just to piggyback, my intention was to insert in this discussion, insert some timelines into especially into cross-examinations or rebuttals. We've talked about it for quite a while. I think the original presentation, depending upon the complexity and the scope of them, and maybe we can talk about limitations there too. But sincerely, I think on the rebuttal pieces of it, that we really closing arguments, that we really limit those timelines.
And Michael, on the rebuttal piece, we have made changes to the rebuttal across all the types of hearings that the board may see, and we no longer make it the default, but it has to be requested and the chair has to approve it. So it will put the chair in the position to ask the other person, what do you need this for? How much time do you need? And determine whether or not that's an appropriate, need to respond and for the board to hear. Because if it's just rehashing more of what the board has already heard, then the chair could cut that off and just move it straight to closing statement. So at least with rebuttals, we have tried to address that. It's more difficult with cross-examination, just because of how the laws are written.
Yeah.
But I do think we've got some room with rebuttal.
Yeah.
I'll add too. So first of all, Emily, I think that's a great idea. And I think that Cassandra, let's try to work something up where we are getting in front of people perhaps before the agenda goes out and asking them, whether it's an email or a form or something we send them, but let's get them on record. That's a totally reasonable ask. And the other thing I will say is, while you will hear some new de novo hearings, I think the great majority of them, and Emily, you can back me up on this or not if I'm overstepping, I think the great majority of them are going to be very straightforward, not particularly time intensive hearings, likely not contested. The ones that are contested, you are likely going to see anyway. Those hearings could end up being longer than they may have otherwise been, but I think you were likely going to be spending that time with with those appellants anyway. So for what it's worth, it is an expansion, but we don't think that this is going to be a tremendous additional burden.
For clarification's sake, is there been any thought to alternating? So we have a standing monthly meeting, alternating 1 month be the appellate side and then one for the de novo hearings, so that there isn't confusion as to what's going on in the court on the day? Or is that not frequent enough for these hearings?
I don't know that we've explored it. it's something we can look at. And if it's something that we can make work within existing timeline and notification requirements, that's something that I think we could aim for, because I can see, I mean, if that's of course too, if the rest of the board agrees, but I can see the value of treating those two things separately and getting your head space in the right space for those.
I have a couple of questions about new section D, the urban design overlay district. So, I mean, because this is a de novo hearing, right? The parties of record might be supportive or against the application that's made. And in subsections C and E, the cross-examination sections, I mean, it doesn't really provide for an opportunity for other parties of record to cross-examine. For instance, in subsection C, it just says where there's more than one appellee. And it doesn't reference other parties of record, just the appellee. I mean, is that even the correct term here? Appellee, should it be party of record?
I think that should be party of record, Jonathan.
Yep.
Yeah, we need to make that correction. That's a good catch.
And then just one other, I think, correction further down in subsection C, the last reference to appellee or its witnesses, I think that should be appellant.
Yep.
Applicant.
Applicant. Yep. That's right. And then in subsection E, so here, I mean, if it only provides for the applicant's ability to cross-examine a party of record, should the ability to cross-examine also extend to other parties of record cross-examining parties of record?
Yeah, if you would like to make that clarification, we can do so. I don't know if it's.
Go ahead. Sorry.
That might almost be something to cross that bridge when it comes, and the board could suspend its rules or the chair could use discretion. But technically, it wouldn't be wrong to do it.
Okay. Yeah, I'm good with that. I mean, if we've got parties of record cross-examining parties of records and applicants in the, I mean, what the concern that Mike just made, I mean, we'll be taking a lot of time there.
Are there any other questions about the changes in the rules or the changes to the urban design overlay districts?
I have
Sure.
one. I mean, so the what frequency would we allow? So we've seen this. I think we've seen an uptick in the appeals process where they're asking for special sessions or sessions outside of the normal scope in the last 2 years. Obviously, we're increasing the volume of hearings that we're going to have. What kind of leeway would you guys foresee on sessions outside of our typical timeline?
And really, that remains, I think, within the chair's discretion, whether to entertain a special meeting. And I think our process has been to ask board members if they're available on certain dates. I think it is generally within the board's purview, whether it wants to make those accommodations or whether it wants to stick strictly to its schedule. I think within reason. I think some of the recent special meeting changes have been due to just weird or strange factors, a confluence of vacations, or unexplained or unanticipated, personal events or COVID, or there was a request for an in-person meeting. So it's been unusual factors that have led to the more recent requests for special meetings. And our hope is that is just that, an aberration and not the norm.
Yeah, I can tell you from sort of the application procedure side that the tone and the expectation that we set for applicants as they come in is that these will stick to the established CBA schedule of Thursdays. I know, I don't know if Emily, you can talk about it at all, but even as they're interfacing with the zoning department, we've made it very clear that their ability to come in front of the ZBA for these UDODs is going to be once a month, and that they need to plan for that as they go through these projects. So, hopefully that's hopefully that's getting through to them. But that will be how we're going to approach these applications, that they have one day a month to really get these in front of a board to get their approvals. And that, the aberrations will be left to chair discretion.
One more question. Does the concept of party of record, there was a definition for party of record in the appeal context in these rules before, that's been removed, and the party of record definition solely relates to the urban design overlay district. Does the concept of party of record, is it obsolete in the appeal context?
I don't think it was ever really used. It was a defined term, but it didn't really have much purpose or value. And that's something we saw when we reviewed this. But it does have value in these de novo hearings. And really what it's saying is it's just another way of saying persons who have standing, legal standing. And the idea is to separate people who have an actual legal right to participate in a more robust way from persons who may be very interested but don't actually have legal rights at issue within the proceeding. They still have the ability to participate through public comment, but not in the more broad way that somebody who has actual legal standing would have to participate.
Okay, makes sense.
So Marion and David, do you need us to make a motion to adopt the changes in the rules with the changes that Mr. Benny brought up?
Yes, Madam Chair, that would be advisable.
So if there aren't any other questions, we'll entertain a motion to adopt the changes in the rules.
I move to adopt the changes in the rules.
Is there a second?
I second.
All in favor, please signify by saying yes.
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 Any opposed? That motion carries. The rules are adopted with the changes that were mentioned. Is there anything else?
We've got a form.
We don't have to approve the form, do we? That's administrative.
I think we should approve the form.
Okay, all right. Has everyone had an opportunity to look at the new form? Is there a motion to adopt the form?
So move.
There's a second? All right. All in favor, please signify by saying yes.
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 Any opposed? Motion carries also. The form is approved. Is there anything else for this meeting?
I have a question. Are you getting applicants for participation on these boards from the city's perspective, or Are there people waiting to take our places? Are you desperate to get staff people? I'm just kind of curious. I don't know, Marion or anybody that's familiar with, it might be Cassandra, I don't know.
Well, Bob, we just appreciate you and the rest of the board members so much that, when you've got the best,
Nice cover from somebody from within.
Why go looking for someone else? But I mean, what I'll tell you is, the city manager has the appointing authority for this board. We keep the city manager's office regularly updated on the status of appointments and the status of board member terms. And it's the city manager's office that determines how it wants to go about filling spots that are open or available. I would say that if you feel like your time of public service is coming close to an end, and we appreciate everything that you've given and contributed, it's probably most advisable to reach out to the city manager's office and have that conversation and ask them what their thoughts are on if they are thinking about finding other persons to serve in your place.
Well, and I wasn't unintentionally trying to imply anything, but it does take a quorum of 4, if I'm correct. We have 5 members, and I know I've made Cassandra's task a little more difficult at times when I was actually on one of the boards that the appeal board was reviewing. And I didn't know how difficult it was to find a replacement to maintain the quorum, which was really kind of my question.
Yeah, and so sorry if I took that the wrong way. I wasn't implying.
Well, I'm going to hold that
anything either. But I mean, that is one of the reasons why we continue to make the city manager's office aware. Is it can be difficult to get quorum at times, and we are always aiming to have a fully appointed board. I mean, that is a goal of ours.
Sure. I don't think there's any reason to think that there's a long waiting list to get on this board. But it's hard to say for sure because the city manager does handle part of that process.
I'm just curious. Thank you.
I can't believe anybody doesn't want to be a part of this
Yeah,
board.
really?
We're great people.
All right. Well, anything else before we move to adjourn? If not, we'll entertain a motion to adjourn.
So moved.
Motion
Is
to
there a
adjourn.
second?
Second.
All in favor, please signify by saying yes.
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 Opposed? Motion carries. We stand adjourned. Thanks,
Take care,
everyone.
everybody.
Thanks, everyone.
Marion and David and Emily, thank you very much for your help.
Yeah, great job. Thanks. This was valuable.